All right, it is 1:30 p.m. Eastern Standard Time. Let's get at it. My name is Dean Blachford. Welcome to Tax Dispute Update 2023. This is the seventh year that we've given this annual presentation, and I'm so glad you're here with us again. This year, we're going to be pulling back the curtain on the tax dispute process. We're going to be doing that by sharing 7 common surprises that catch up tax dispute clients. These same 7 surprises also tend to catch up their accountants. So we'll be sharing them today with you, and we have a bonus 8th surprise at the end. Now, I want to let you know from the outset that these surprises are not very happy surprises. At the end of a tax dispute, you don't get 2 free tickets to go see Taylor Swift. But I wanted to share them with you because A, they will help ensure that you don't get caught with mistakes. We're going to talk about some very serious mistakes that do catch people up. We want to avoid that. 2, I want to make sure that you know that you can help your clients avoid these tax disputes at the outset. To the extent possible that you can do that, I want you to be motivated to do that by hearing about the content we're going to be sharing today. And then finally, I want you to be able to make informed strategic decisions at the outset of the tax dispute process, so that you can help your client obtain the best result possible as efficiently and effectively as possible. So we're going to cover all that in the following hour. So by way of introduction, this webinar is sponsored by Audit Shield. We're so glad to have Audit Shield sponsoring this webinar for the 3rd year in a row. Partway through the presentation, I'm going to be showing you a 2.5-minute video interview that I did of Jason Koenig of Audit Shield, where he shares some up-to-date current data on CRA's most recent audit activity. There is a question and answer period at the end. Please put your questions into the Zoom Q&A feature at any point, and we'll get to as many of those as possible at the end of the presentation. There are a couple poll questions in this presentation. I would love it if you participated in that. It helps us get feedback on where you stand, and it helps make the presentation more engaging. There's also a survey at the very end of the presentation that'll be sent to you automatically. We would love it if you filled that out. We're always using the data from that survey to make sure that we're trying to improve this presentation every year. And we typically get very good uptake on that survey. A lot of people fill it out, so we're always grateful for that. Finally, a quick bio. So again, my name is Dean. I am here from Blachford Tax Law. I grew up from Vancouver, BC, and I did my law degree at McGill. After that, about 10 years ago, I moved here to Ottawa to participate in the prestigious Tax Court of Canada clerkship program. So I recently came across this photo. This is me here in the clerkship. And so I did that. This photo was taken 10 years ago. After that, I went into private practice, and ever since then, I've been helping taxpayers solve significant tax disputes with the CRA. About 2.5 years ago, me and my colleague Ella branched out and launched Blachford Tax Law. And ever since then, we've been helping clients across Canada with their tax disputes. So the first surprise, deadlines for initiating a tax dispute are final. I wanted to talk about this surprise first because it's so important. If you don't get your tax dispute off on the right foot, if you don't launch it and initiate it the right way in the right time frame, your tax dispute can be hooped from the very beginning. So let's start by reviewing the tax dispute process. This is going to be a review for a lot of you, but bear with me as we ratchet up. So we typically start with an audit, then we move to an objection to CRA, and then we move to an appeal to the Tax Court of Canada. Of course, there's a Federal Court of Appeal and a Supreme Court after that, but this is where most of the tax disputes get resolved. Now, at the end of each of these steps, particularly the audit step and the objection step, there is a document that CRA issues. And that document is critical because the date on which that document is issued starts a time deadline ticking that we're going to talk about in the next slide. At the end of the audit stage, there's typically a notice of reassessment that gets issued. At the end of the objection stage, you either have a notice of reassessment if CRA has made a change at the audit stage. So hopefully they've made a big change, but they could also make a partial change. or they have a notice of confirmation, which they would issue if they're sticking to the auditor's result. So for each of these documents, they have a date on them, and that starts the time deadline. The time deadlines are the same from moving from the audit to the objection stage as they are from moving to the objection to the Tax Court of Canada stage. And we'll talk about those in the next slide. But before we do, I want to talk quickly about jurisdiction. Jurisdiction means the power of a legal body to make a type of decision. So we think of the Tax Court of Canada as having kind of jurisdiction to decide anything to do with taxes. But in fact, their jurisdiction is quite limited at the court. And so that's going to come up time and time again throughout this presentation. One way in which their jurisdiction is limited at the tax court is that they cannot overturn a notice of reassessment if the taxpayer did not file a notice of objection to that reassessment. I'm going to say that again. If the taxpayer doesn't file a notice of objection within the timelines, they cannot skip the objection step and go to the Tax Court of Canada. The tax court does not have jurisdiction in that case. It only has jurisdiction if the taxpayer has filed a notice of objection within the time frame. So what are those time deadlines? Well, we start here on your left with the notice of reassessment or notice of confirmation. It could also be a notice of assessment. That's going to start a timeline ticking. The date of issue is what matters there. It's not when the taxpayer receives it. It's not when they open it. None of that matters. All that matters is the date that is issued, the date that CRA sent it. From that period, 90 days starts to tick. And in that 90-day period, the taxpayer has the right to either object to get to the objection stage or file a notice of appeal to get to the tax court stage. Nobody can tell them no, that is their right. But after that 90 days, if the taxpayer hasn't filed their notice of objection or their notice of appeal, there's a 1-year grace period in which they can file an application for an extension of time to file their notice of appeal or notice of objection. At that time, there's now some discretionary decision-making on the part of CRA. Your right to object or appeal is not absolute. Now, thankfully, CRA typically allows applications for extensions of time, but you want to make sure you're doing that the right way. If it's a significant amount in dispute, you're probably going to want to get some counsel on that. At the end of that 1-year period, so at the end of a total of 1 year and 90 days, the taxpayer does not have a right to object, and neither CRA nor the tax court have jurisdiction to overturn that notice of reassessment. That's really important. They have no power, even if you talk to someone really nice at the CRA, and a lot of people at the CRA at the call desk, they won't necessarily know that, or they won't understand that, and sometimes you get false hope. But really, there's virtually no power on the part of CRA. Couple exceptions. One is that you can file a taxpayer relief request, but that's only to do with penalties and interest. So that's not going to help us when it comes to the substantive tax at issue. The other exception is called a remission request, but it takes an act of parliament. These things are very, very, very rare. So again, if you miss the 1 year and 90 days, the taxpayer has no recourse to dispute their notice of reassessment or their notice of confirmation. There's nothing that CRA can do and nothing that the court can do. They don't have jurisdiction. So that brings me to my recommendations for this first step. First, be alert to the deadlines. You never want a situation in which your client instructs you to file a notice of objection or a notice of appeal, and they instruct you before the 90 days is over, and you don't get to it till after, or worse, after the 1 year and 90 days. That would be an obvious negligence claim that would not be hard for a taxpayer to establish against you. So that would be terrible. And speaking of this, that's one of the reasons I like Audit Shield. I feel like I hear often that accountants are writing off time when they're dealing with their tax disputes. And if you're writing off time, I think it would be natural to not prioritize the work that you're essentially doing doing as a volunteer. I know you are all so busy right now with all the work that you have to do. I think it would be natural to prioritize the paid work. The problem with that is if you miss a deadline because you haven't prioritized that work, that would be a huge blow to you and cause major issues. So Audit Shield, by making sure you get paid for that work, levels things out and makes sure that you're properly incentivized to do your tax dispute work. The other thing I wanted to mention with as far as recommendations is use a notice of objection over a T1 or T2 adjustments. I sometimes hear of accountants defaulting to using a T1 or T2 adjustment when they should be using a notice of objection. A T1 and T2 adjustment does not satisfy that 90 days or year and 90-day time deadline. So you could file a T1 adjustment, later find out that CRA is not accepting it, the year and 90 days has passed, and your client now has no recourse. So if you're ever in doubt, file a notice of objection. You can always file a notice of objection and just attach the T1 or T2 adjustment and say, I object, please see the T1 or T2 adjustment for how this should have been assessed. Surprise number 2, surprise! The burden of proof is on the taxpayer. Now, I know a lot of you know this already, but I think as tax professionals, we not only need to know this, we need to understand how it works in reality, and we need to know for sure the exceptions. So how does the burden of proof work in reality? Well, first off, CRA gets to take a position, and we have to prove that they are wrong about that position. Now, the burden is on a balance of probabilities. What that means is it differs from another standard, which is, for example, the criminal burden of proof, which is beyond a reasonable doubt. So we do not have to prove beyond a reasonable doubt that we're right about this tax dispute. We have to prove on a balance of probabilities. That means that the judge would have to accept that there's a 51% chance that we're right. But that extra 1% is a big deal. Now, the way that this works in reality is CRA can rely on assumptions. When CRA files when we file a notice of appeal to the tax court, CRA files a reply back. It's a document, and it states their case. And in that case, it has a full section that's called assumptions. And that lays out all the assumptions that CRA is making against our taxpayer. I've copied a few assumptions that have come out of replies that I've had over the years. The first one, as an example, says, during the taxation years, the appellant did not declare income from his contracting services on his tax returns. So that's an assumption CRA makes, and we have to prove it wrong. The problem is that our client didn't have a contracting service. So we now have to prove a negative, prove that our client didn't have this business. You can imagine the burden that places on us. Another example is the appellant had total income of $634,000 in 2011. So that's a huge burden. Again, we have to prove that they didn't have this amount of money. If we don't disprove it, the court has to accept that as being correct. Third, the appellant appropriated the cash sales. Again, we certainly did not agree that the client appropriated cash sales, but we have to prove this negative. We have to disprove that they appropriated those cash sales. Again, it's a huge burden placed on us. What are the exceptions to the burden of proof? Well, thankfully, the burden of proof is not on the taxpayer when it comes to gross negligence penalties. This is a big deal because, as you know, gross negligence penalties are huge. For income tax, it's another 50% of the tax added on. Under the Excise Tax Act, GST and HST, it's another 25% added on. So it's a big deal that that the burden of proof is not on us, it's on CRA. And the courts have interpreted it as a fairly high burden. They don't want CRA assessing these gross negligence penalties kind of willy-nilly. Another thing that comes out of this is that CRA can't rely on assumptions when assessing gross negligence penalties. So that's something you want to keep your eye out, and we certainly use against CRA if ever we see assumptions in their penalty report. The second exception is misrepresentation. If CRA wants to assess a taxpayer beyond the statute of limitations, typically 3 years for an income tax dispute, they have to prove that the taxpayer made a misrepresentation. Now, unfortunately, the standard that that the courts have interpreted for misrepresentation is quite a bit lower. They don't seem to expect as much to establish misrepresentation as they do for gross negligence penalties. For example, I've never had a situation where I called up an appeals officer and said, oh, you've assessed this taxpayer, but 2 of the years were statute barred, so you should just throw it out because you're never going to be able to establish misrepresentation. They typically feel confident that they're able to do that. If they've audited you, if they've reassessed the taxpayer, they probably feel like they have misrepresentation. And so this can be helpful in negotiations towards the end, but it doesn't stop us from having to really build our case to refute that misrepresentation assessment. So what are the recommendations with regards to this, with this surprise? Well, first, start building your case early. Again, that burden of proof being on us is a big deal. The best way to be able to satisfy that burden, to demolish those assumptions, is to have really good documentary evidence. And the only way you get that is by starting early. It also starting early also helps with with the client's memory, getting those details while they're still as fresh as possible in the client's mind. So start early. Two, when the burden is on CRA, use that in negotiations. So we really effectively use this to counter gross negligence penalties. And this can be a huge success for clients. Like I said, it's a big deal. Finally, don't over rely on the statute of limitations. Yes, it's good when a taxpayer, when CRA has missed the limitation period for their assessment, but it's by no means a get out of jail free card. We still have to do the work to prove that the taxpayer filed their tax return properly in the first place and that CRA is wrong about their misrepresentation assertion. Surprise! Your client's memory is not entirely reliable. So this surprise works in tandem with the next surprise, and it's something that comes up over and over again. I am constantly having situations where a client will come to me and they will tell me how a tax situation went down according to their memory, and later, after I've pushed and pushed a little bit, it turns out that the documents or the recollections of other people show that it happened quite differently. This isn't because my clients are lying to me. It's because it's really hard to remember these transactions, which are many years in the past. So what we have to do is, again, push and push. My job as a tax lawyer is to push and push on my client to make sure that they're remembering things accurately, that they have documents to support it. I was in a litigation one time when I went into closing arguments, and the Department of Justice lawyer brought up a letter that the accountant had sent to the CRA auditor many years in the past that detailed what the accountant had been told by the client about how the situation unfolded. Many years later, when we're now in front of the court, the client's story had changed because the documents had jogged his memory, and he had now realized that, oh, my initial recollection of this wasn't correct. The DOJ lawyer, Department of Justice lawyer, used that inconsistency to assert that our client was not credible. A lot of people think that credibility comes from just not lying. And of course, that's important. But credibility also comes from having a really crisp memory that lines up with the documents and the other evidence. And the only way you can do that is by pushing on that memory and testing that memory to make sure the facts are accurate. Surprise, your client does have documents. So this is one of the few positive surprises of the webinar today. Your client does have documents to support their memory, to help clarify their memory, but often they don't initially look hard enough, or they don't fully understand which documents would be valuable. So I had a recent situation involving a tax flipping file where the client came to me and they had bought an old rundown house. They demolished that house, severed the lot, and built 3 houses on it. This was a construction worker who did this. The first 2 houses he sold. The third house he lived in for a little while and then couldn't afford it and sold it after 10 months. He claimed the principal residence exemption on the third house so that the gain would be tax-free. And CRA came back and said, hold on a second, we think you were intending to flip that house, that third house, all along. We're going to deny your principal residence exemption. Now, if you're not following all this, send me an email because I have lots of resources on house flipping cases, and I know it's a very hot topic issue. So the client comes to me, and initially he said, no, I don't have any documents that would be helpful. No, I don't really have anything. I just can tell you my story. But after a little while, it came out that he had actually bid on a house that was across the street a year prior to getting the rundown house. And so I pulled up the MLS listing on that house, and it was a beautiful, finished house that had actually recently been renovated. So I talked to his real estate agent about it. I said, "Tell me about this first house. Would that have been a good house to knock down and put infills on?" He said, "No, you'd never make your money back on that. You're paying too much for the house." I said, "Would it have made sense for him to do some like cosmetic refurbishing and then sell it and flip it that way?" He said, "No, still the margins, you're never going to make money because it's already too nice. You're paying for too nice of a house." And so I got him to put that in a letter. Now we have an MLS listing document and we have a letter from the real estate agent that support that this client wasn't looking for a shabby house to knock down. He was looking for a house on this particular street. And when he couldn't get the first one, he had to go for the second one and try and make it work by doing this infill project. You can see how that very much shifts the narrative, and it's all compelling because of the documents we have. So again, memories are going to be weak. We need to test those memories by trying to get documents. And your client actually has more documents than they think initially. We just need to kind of coax them out of them. So that brings me to the part of my presentation where I'm going to show this video with Audit Shield. After we get back, there's more surprises and there's a couple poll questions that I'm looking forward to asking you. But for now, let's hear from our sponsor and Jason Koenig on recent CRA audit activity. Jason, thanks so much for being here. Tell me, what have you seen from CRA over the past year?
Hi, Dean. Sure, absolutely happy to share. Looking now at the second year since emerging from our COVID lockdowns, there's no doubt that the CRA has got their mojo back and they seem like they're back in full force. We're seeing the highest level of activity that we've ever seen before. In fact, this past September, from our claims department at Audit Shield, we saw a 57% increase in claims activity from the CRA as compared to the previous September. Now, to lend a bit of perspective to you, we've been in the Canadian market now for 7 years, and we've accepted and paid out on more than 22,000 claims at Audit Shield. And this year, we're pacing at a rate of about 25% higher than the previous year.
Wow. Okay. And what specific audit activity is CRA keying in on?
Sure. On the T1 side, we're seeing a lot of the T1 processing reviews, that special assessment and matching programs. And this is an increase from last year. It's like they're almost playing some kind of catch-up game. Of course, we're seeing a lot of the T2 corporate post-assessment reviews, your FTCs. We've most recently started to see the Apprenticeship Job Creation Tax Credit, the AJCTC. And of course, and I'm sure we'll get a lot of head nods on this one, is the professional fees and your vehicle expenses, the logbook stuff that we tend to see quite frequently. And we're also seeing a lot of these payroll trust reviews, also seeing the GST, HST, PST, QST pre and post assessments. And of course, we continue to see the SUs and the SIRS of the COVID subsidies. And in the coming weeks, once the deadline has come and passed, we're expecting to see the underused housing tax, the UHT.
That's right. Okay. Now, Jason, if you had to explain in a nutshell to CPA firms who are watching this today, what would you say is the most important or most valuable part of working with Audit Shield?
Well, Dean, traditionally we know that many CPAs are writing off their time and responding to these inquiries. So with Audit Shield, it allows CPAs to push that reset button, on who pays for this type of unplanned and, quite frankly, unwanted review activity from the CRA. So it lets you do your best work and without having to worry about your time, because guess what? It's all covered by Audit Shield.
Thanks so much, Jason.
You bet.
Okay, thank you again to Audit Shield and Jason for that inside scoop. Our next surprise, settlements must be principled. Now, before I tell you more about that, we're going to go to our first poll question because I want to hear what you have to say about this. So the question here is, poll question, which of the following is not true? Principled settlements reflect the correct application of the law to the facts, are based on compromise and reducing litigation costs, differ from settlements in civil litigation between citizens, and are intended to reduce arbitrariness. So which of these is not true? I want to know how much you know about principled settlements before I tell you about this. Okay, Ella's going to pull up the answers. And it looks like many of you got this correct. There's answers for all of them, but it looks like many of you got this correct. Many of you said 2, and that is the correct answer. And I want to tell you why. So a principled settlement reflects the correct application of the law to the facts. What that means is a principled settlement has to be a conclusion that a judge could have come to. So taking that house flipping example for a moment, the court couldn't decide, well, you're entitled to 50% of the principled residence exemption, or you're entitled to 20% of the principled residence exemption. You either get it or you don't. So you can't have a settlement agreement that says, we'll split it 50-50, or we'll give you 20%. Clients are often coming to me saying, Dean, I've got this tax issue. It's super complicated. Just offer them 20% and we'll be done with it. It just doesn't work that way, unfortunately. 2, they are based on compromise and reducing litigation costs. That is wrong. So on our side, maybe we're considering those things, but that's not how the settlement agreement has to be. Can be what it can be based on. Again, it has to be based on the correct application of the law to the facts, and nothing else. If the Department of Justice lawyer were to agree to a settlement like that was based on compromise, oh, we'll give you 50%. Let's, maybe we say, oh, look, like this is a complicated issue. We don't really know how this is going to be decided by a judge. Let's save ourselves all the costs and just go 50-50. A Department of Justice lawyer just is legally not entitled to agree to a settlement like that. Neither are CRA appeals officers at the objection stage. 3, they differ from settlements in civil litigation between citizens. So this is true in between citizens. If you have a lawsuit with your neighbor, you are encouraged to make settlements that are based on compromise, that incorporate litigation costs, and try and reduce all that and spare the court the time. But it's different when you're in a dispute with the Crown. The Crown is held to a higher standard, and they're not entitled to make negotiations or enter into settlement agreements like that. Finally, 4, they are intended to reduce arbitrariness. That is very true. So that's the crux of all of this, is the reason why the Crown has to enter into principled settlement agreements is because Parliament doesn't want arbitrariness when it comes to how these are settled. They don't want a Department of Justice lawyer in Halifax agreeing to cushier settlement agreements than someone in Vancouver, a Department of Justice lawyer in Vancouver. So by forcing the Department of Justice lawyers to only settle if it is consistent with something that a judge could decide, that reduces the chance of arbitrariness. So my recommendations for this one are, A, don't mislead your client based on about the settlement process. I recently had an accountant send me a client, and it was a big, messy audit, lots of years, lots of different issues. And he said, don't worry, Dean's going to get 33% knocked off at the objection stage and another 33% knocked off at the tax court stage, and he'll get this behind you. And I think, oh my gosh, don't tell your client that, because we want our clients to feel like the system is not arbitrary, because I need my clients to be engaged in the process. I need them to be focusing on what's in their control. I need them to know that they can control part of this by getting the documents I need, by attending my meetings and letting me ask them questions, by reviewing the documents with me, by rolling up their sleeves and doing the work with me. That's how we win these things. The result is not arbitrary. It's not willy-nilly. It's not based on happenstance or litigation costs. It has to be the legal and factual analysis that gets us to a settlement. And I don't want our clients taking their eye off that and thinking that the whole system is rigged against them or it's totally random. So please don't send me your clients telling them that I'll just get a certain amount knocked off. It's just not how it works in reality. Before I go to the next surprise, Ella, just during the last poll question, came in and said that we have over 300 people on this webinar right now. That's incredible. Thank you so much for being here. It still blows my mind. I also heard that there are going to be some watch parties out there. So if you're at a watch party right now at your firm or at a pub, I don't know, take a photo of yourself for me, because I would love to see what it looks like at the other side of the screen. And thanks so much again for being here. Surprise number 6, appeals to the tax court take a long time to resolve. I have to say this is the surprise I'm the least excited to talk about, because it's just frustrating how long these things take, and I really understand how frustrating that is for our clients who want to get this resolved, who want to get this behind them. I want that for them too. So before we talk about the tax court process, the average objection processing time right now for a medium complexity audit is about approximately 1 year. For a high complexity audit, it's approximately 2 years. So that's how long most of our audits are. The objections that we deal with are in that medium to high complexity range, and these things take time. That includes several months while after we file the notice of objection, while we're waiting for an appeals officer to be assigned. So that's part of this 1 year. We really need to take advantage of that time while we're waiting for the appeals officer to be assigned. We want to be gathering the documents. We want to be preparing our analysis. We want to be writing compelling submissions. That all happens during that time, so that the moment the appeals officer gets assigned to the file, we've sent them our full submissions with all the documents needed, and we're ready to take full advantage of having this appeals officer and getting this second review of the auditor's work. After the objection process, so I often have clients who say, okay, if they get towards the end of the objection, they say, enough of this, I'm done dealing with the appeals officer. I want to go to the tax court. I want to take this before a judge. What they don't realize is, if you're under the general procedure, which is what most of my clients are, there's a bunch of steps that have to get done before you ever get in front of a judge. And those steps take a long time. So right now, after we file the notice of appeal, the reply has to come back within 60 days of them receiving it. So it takes about 2 months for us to get the reply back from the Department of Justice lawyer. Then it typically sits idle with the tax court for what typically ends up taking a few months. Then we're filing a timeline request, and we get this timeline from the tax court. And the timeline has all these steps that we have to complete, and they usually have a 2-month deadline for each one. Sometimes it's less, sometimes it's more, but they average out to about 2 months. So, for example, we have to exchange our list of documents with the CRA, with the Department of Justice lawyer. We have to participate in an examination for discovery, where the Department of Justice lawyer gets to interview the taxpayer on the record, and they have to answer all these questions about their documents and about their case. Then we get undertakings from those examinations from discovery, where CRA asks us follow-up questions, essentially, and we have to provide the answers to those. That typically takes another 2 months. Then at the end of that, that's the sweet spot for trying to settle these. So we try to settle them at that stage, if not before. If we can't settle them in that last 2-month period, then we communicate with the court, and they set it down for a trial. But when they're setting it down for a trial, it's not like it's tomorrow. It's typically like 8 months, 10 months, 12 months away, depending on how many days we need before the judge. So that is a huge process, right? If you just add up these months, you're talking about 13 months there on average before you even ask the court to set a date for your trial. Like, it can easily be 2 years. So it's a very, very arduous process. It takes a lot of work, these steps. It's stressful. So that takes me to my recommendations, which is, number 1, help your clients avoid tax disputes in the first place. I feel like I'm preaching to the choir here. If you're one of the 300 plus people who are on this webinar, you're one of the people who's trying to help your clients avoid tax disputes in the first place. 2, help your clients put their best foot forward at the audit and objection stage. I can't say this enough. Auditors sometimes get set in their ways. Once they get fixed on a position, it can be very hard to get them to change their mind after they've put all the work in. But that objection stage is so crucial. We're now doing the majority of our work, I would say 60 to 70% of our work, at the objection stage, because it's just such a more efficient way of getting the problem resolved. So we push really hard at that objection stage. to get the result that we want without having to file a notice of appeal. Yes, we do have to file a notice of appeal on occasion. We do it if we need to, in order to exercise our client's rights to get the right deal. But to the extent that we can get it resolved at the objection stage, that is a huge, huge load off for our client. It's a huge success for our client. Surprise, CRA won't cancel interest as part of settlement negotiations. So this is, I would say, the number one surprise that catches taxpayers off guard. And I would say it's the most frustrating surprise for taxpayers. It is, I think, in a lot of our clients are business owners. Typically, if they need to get a deal done, interest is the first thing to go. But that's not how it works at the tax court stage. And so that brings me to my second poll question, which is the following. Which of the following is not true? Number one, interest accrues on the amount ultimately owing throughout the dispute. 2, CRA can collect GST, HST while the dispute is proceeding, but not income tax. 3, a tax court judge can cancel interest. 4, CRA's interest rate is currently 9% annually. Which of those is not true? And we will post those answers. So it looks like I was going to post the responses, and it looks like, yes, you're right. Many of you are right. A tax court judge cannot cancel interest. Number one, interest, let me take you through all these. So first, yes, your interest does accrue on the amount ultimately owing throughout the dispute. So if we have, imagine a dispute worth $500,000, we end up settling for $100,000. Interest will have accrued on that $100,000 throughout the tax dispute process if it wasn't paid off earlier. So that $100,000, if it's never paid until the end of the tax dispute, interest will go back all the way to the year that it should have been paid, not when the audit is finished and it's reassessed, all the way back to the initial year. So that interest amount can add up enormously. If there's penalties, there'll be interest on those penalties as well. Now, if the taxpayer had paid off that $100,000 toward it, that would have stopped the interest on that $100,000, and obviously there's no interest on the $400,000 that we got knocked off because that amount is not owing anymore. 2, CRA can collect GST, HST while the dispute is proceeding, but not income tax. That is also correct. So while a dispute is going on, CRA can collect GST and HST. The government thinks that considers these trust funds, and so they feel like the taxpayer was holding those amounts in trust, so they can go out and get it even while the dispute is underway. The Excise Tax Act gives them the power to use all their collections action, seizing account, liens, requirement to pay to customers, etc. All those kind of nasty collections of powers that CRA has. They can do that during the tax dispute process. So we're often on the phone with an appeals officer on one end, disputing a GST, HST issue, and then the collections officer on the other line, trying to negotiate a payment plan. That's something reasonable that will prevent them from taking collections actions. With regards to income tax, CRA cannot collect that during a dispute, so long as you're not a large corporation. So the moment that we file a notice of objection, CRA can no longer collect on that amount, and it's not until the dispute is resolved that CRA can come back after that money. Now, that doesn't stop the interest from accruing during that period. So this is a benefit to us, but not a huge benefit, because if it turns out that part of that amount was owing, then interest will have accrued on that. But if we're successful, then obviously we didn't have to pay that amount initially. 3, a tax court judge can cancel interest. That's wrong. A tax court judge, this is another jurisdiction issue that I mentioned to you earlier. Tax court judges do not have the power to cancel interest. It's not in their jurisdiction. They can only deal with the actual substantive tax, with the amount that's an issue, how the law applies to that, not interest. And so the CRA and the Department of Justice lawyers know that. And so they will not negotiate interest as part of a settlement agreement. You can go to the taxpayer relief department, file a taxpayer relief request, and try and get the interest knocked off that way or reduced that way. But it has nothing to do with the tax dispute. That your argument to the taxpayer relief people has to be, financial hardship, extreme financial hardship, or extraordinary circumstances, etc. And CRA, my experience with those taxpayer relief requests are that they are very frustrating, and CRA is not particularly forgiving, despite what our clients think they should be knocking off as far as interest. It's often quite disappointing. For CRA's interest rate is currently 9% annually. That is true. It's a high amount. Yay, inflation. Paying off amounts in dispute. You can pay off part of the amount. So a lot of clients will come to me and say, okay, when it comes to paying off this amount, can I make a partial payment or do I have to pay the whole thing? No, you can certainly make a partial payment, and anything you pay will stop interest from accruing on the amount that you've paid. 2, CRA will repay any amount overpaid plus interest. That's true. So in that same situation where we start off with a tax dispute of $500,000, we get it settled for $100,000. If the taxpayer had paid $200,000, CRA would pay back the delta, the extra 100,000 plus interest on it. It's not 9%. They don't pay as much interest as they charge, but there is some interest that comes back. So it's a nice component of paying your tax dispute amount at issue during the dispute. 3, not an admission of guilt. A lot of clients worry about this. Dean, I don't want to pay the amount because they're going to think that means I know I'm guilty or that I think I'm guilty. And that is certainly not the case. Often the people that we're negotiating with, either the appeals officer or the Department of Justice lawyer, they don't even know whether the amount has been paid or not, because that's dealt with by a totally separate department at CRA. So it is certainly not an admission of guilt. And I don't think it's a sign of weakness, even if the Department of Justice or the CRA did know. I don't think it's a sign of weakness. I think it's a bit of a flex. You're saying that, hey, I'm not fighting this because it's a cash flow issue. I have the money to pay, but I'm fighting because I know I'm right, and I'm prepared to invest in this dispute, and I'm prepared to fight it. That, I think, is a very strong and compelling argument and a sign of strength, not weakness. Recommendations. First, ensure your client knows that the interest accrues throughout and that CRA will not cancel it as part of the settlement agreement. So we want to tell our clients that early. We never want them coming back to us later and them saying, wait a second, what do you mean interest? We want them to know up front so that they can make informed decisions, and we want to encourage them to the extent possible. It is usually a good investment for them to pay as much as they can towards their tax debt while they're going through the dispute. 2, encourage your clients to pay as much as they can. And 3, help calculate potential settlement outcomes. Something that's often helpful is if I have a tax dispute where the client knows, okay, I don't think I'm going to win this whole thing. I think we're going to have to settle and we're going to owe some of it. If I can go through the potential settlement outcome and then share it with the accountant, and the accountant can then calculate how much that would result in owing based on the specifics of the taxpayer's tax situation and the interest accruing. So that's something that I can do but my numbers are typically quite crude relative to what an accountant can do with their software. So that's a huge value add you can provide. That's why I love working closely with accountants on tax disputes, because it's something that you can do that really adds value and helps the client make informed decisions. So with that, I now want to take a moment before we get to our last bonus surprise in our question and answer period. I want to take a moment to talk to you about a few ways you can stay connected with Blachford Tax Law over the next year if we're not currently working on a file together. So the first is through the Blachford Brief. That's our quarterly e-newsletter. So we send that out via email. It's got a video. It's got some articles in it. All the content in there is designed to help you help your clients avoid tax disputes. It includes articles that we've written that should be very relevant to you. It includes journalist articles that have quoted us. It includes notifications on some of the other events that were happening. that will provide you with valuable information. So it's all in there. You get it once a quarter. It also has this community news section that I write that is all about the tax and accounting community. It I often get nice feedback about those articles. And last year, for example, at Christmas time, we wrote an article about all the community work, the charity work that accounting firms in Ottawa were doing in the area ahead of the holiday season. And that was super nice. I really enjoy reading those articles. So if that's not coming into your inbox, if it's not coming into your focused inbox, make sure you're getting it and do check it out. I'm always grateful for that. Second is our CPA Ottawa tax update. So this is an event that happens typically late February, early March, and it's me working with CPA Ottawa to host this tax update. We always get really great speakers. Our attendance keeps growing, and it's a fantastic webinar that will get you up to speed ahead of tax season. And now that we're doing it virtually instead of in person, we have people tuning in from across the country. You don't have to be a member of CPA Ontario. You can be a member of the public or a member of a CPA in a different province, and you can still attend this and get the benefit from it. So you will hear about that through the Blachford brief and through our emails. Third is the Blachford Tax Law Charity Game. This is an event that's near and dear to my heart. We have it every year for the past 5 years. This year, we had over 35 accountants participating, over, I believe, around 15 firms. It was a fantastic event. We had fans out this year as well. So it's very exciting. It's become very, very hard to get everyone in who wants a spot on the roster. It's become very tight for roster spots now. I actually had an accountant approach me at the airport when I was flying away for summer vacation to be like, hey, I need a spot on one of these rosters. So it's really grown in popularity, and it's very fun. And thanks to our sponsors, we're able to donate to charity. Last year, one of the teams represented the Canadian Council of the Blind. The other represented the Ottawa Food Bank, and we donated $10,000 to charity. So it's a fantastic event. And if you want to come out as a player or a fan, we'd love it. We are trying to get more and more fans each year. This is new. So this year, I did a course with Video Tax News. Those of you who've been reading my content and watching my videos over the year know that I'm very concerned about net worth audits. We do a lot of them. They are huge, nasty audits, and they are extremely stressful for clients. And I, for some reason, really enjoy helping clients get them behind them. It's an immense relief for the client, and me being able to call up a client and say, it's over, we've got it resolved, it's done, it's behind you. It's very gratifying. So I did this course with Video Tax News all about net worth audits. It's called The First 7 Steps for a CRA Net Worth Audit, a guide for accountants in Canada. I think it's really valuable information. I did it with Caitlin Butler. You probably know her. She's fantastic. And so it would be great if you check that out. You can Google, just put those words in Google and you'll find it, or send me an email and I'll direct you to how to register and order that course. Again, we do have a survey. I would love to hear your feedback after this, so it'll come to you via email. Please take a couple moments to fill it out. It's quite short. Thanks again to Audit Shield. We really appreciate you having you here, and this is my bonus surprise. So, surprise, judges cannot make decisions based on fairness. This surprise, so we've talked about going through the tax dispute process. I now want to talk about what happens if we actually get in front of a judge. And that is the question is there hope? And there is hope. There is hope. But that hope comes from doing the work. It comes from finding the documents. It comes from reviewing the documents. It comes from researching the case law. It comes from putting in the work. It does not come from a whim and a prayer. It does not come from an expectation that the judge will understand us, sympathize with us, or act or act based on fairness, decide based on fairness. So a tax court judge does not have jurisdiction. Again, jurisdiction comes up. Does not have jurisdiction to make decisions based on fairness. They don't have the power under the Income Tax Act or Excise Tax Act to make decisions based on fairness. They just can only apply the letter of the law. And so we can't be headed into a trial thinking that a judge is going to be sympathetic or acting in accordance with fairness. It's about the law. It's about the facts. Two, CRA's behavior is irrelevant. So a lot of people think, I'm taking this to court. I'm going to show the judge. I'm going to kind of push back on CRA. I'm going to get at CRA. I'm going to show the judge how poorly they've behaved. Judges won't even listen to that because it's totally irrelevant. What matters is the notice of reassessment correct? Apply the facts to the law. Anything that happens during the audit stage or afterwards is not relevant to the tax dispute. So if I were to go into litigation and bring up how the auditor treated my client, or even ask why did CRA audit this client? Are they picking on this client? None of that is relevant. We won't find answers for that. We won't be able to make those arguments before a judge. So as frustrating as that is to clients, because if they're treated inappropriately, if they're not treated with respect, it is very frustrating. But the resolution for that from that will not come from a tax court judge. And so we shouldn't be heading into a trial expecting to kind of show CRA or shine the light on CRA's poor behavior, because it just doesn't happen that way. Judges are type A. The reason I say this is just because I sometimes have clients come to me and say, well, surely a judge will understand that I didn't have this document, or I didn't amend this document, or we acted in good faith based on trust. We don't have a contract. And we can win disputes based on verbal contracts, and we can find other documents, but we have to do extra work then. We can't be heading into a trial saying, oh, a judge will understand, because these judges they're nice. I worked with a lot of them. Some of them were my mentors, but they are buttoned down, type A people. They're at the pinnacle of their career, and they got there because they dotted all their I's and crossed all their T's. And they will expect the same from their taxpayers and their accountants. And so if we go in expecting some sort of lenience or understanding, that's a recipe for disaster. 4, the judges are bombarded with sympathetic circumstances all the time. So they see unrepresented clients. They see new Canadians coming who didn't understand the tax system. They see people who are in very low financial circumstances who are coming before the court, who are pleading their case. And so all these sympathetic circumstances, they kind of have to tune it out. And so if we're going in front of a judge saying, oh, they're going to be sympathetic to us, or they'll understand, again, it's not the way to do it. It's not going to be the result you receive. There's too many sad stories out there for us to expect our sad story to warrant special treatment from the judge. So when I talk about both the tax court stage and the appeals stage, the objection stage, again, there is hope. There is hope at these stages. We are often getting really great results, and I get to call clients and give them good news. But we get those results because we work hard, we roll up our sleeves, we do the work, we pay attention to details, not on a whim and a prayer. And so that's what I need our clients to know. I don't want that to be a surprise from them when they realize that, hey, this is going to take work on your part. If we're going to win this thing, you're going to have to be invested. You're going to have to work on your part. I want them engaged. So with that, we're now going to head towards the question and answer period. So I am going to have these questions I'm going to bring in front of me now. And I'm going to try and answer these as quickly as possible. So what is the success rate at the court level for an ABLE claim with limited source documentation? Example, client doesn't have bank documents to support loans to corporation and can't get it from the bank due to passage of time. So it's going to be hard. If CRA ABLEs are hard with CRA, they're very reluctant to give them in the first place. And if you have no documentation, it is going to be hard. So every case is different. And I can't, say one way or another. And I wish I could give you a percentage, but I can't. But I would say if you don't have documentation, you're going to have to find a lot of other evidence to support that claim. And you're going to have to hopefully find other evidence that support it. It might not come in the exact way you're thinking right now, but there is going to have to be some documentation to support the taxpayer's testimony. I would be very careful about, going into tax court thinking that you're going to win that one and investing a lot without really taking a critical look at your case. I don't want to kind of paint that as a rainbow. It's the winning these things is not easy with the burden of proof on you. Excuse me. Question: do you feel that the appellant had a total income is a determination under Section 9 and is a determination of law? So I'm not fully understanding that question, but I would say one thing I wanted to mention is there are questions of fact and questions of law. When it comes to assumptions, CRA is entitled to make assumptions with regards to facts. They are not entitled to make assumptions with regards to law. So they are not allowed to say, oh, the law works this way or the law works that way without providing support for that. The reason is that the reason we have the burden of proof on us and CRA can make assumptions about the facts is because the facts are in our unique possession. Only the client knows what happened in their personal life or in their financial life. And so that's why the Parliament has put the burden of proof on taxpayers for them and allowed CRA to make these assumptions. But again, that does not apply to the law. CRA can't make assumptions on the law, and I do find that happening sometimes, and it's certainly something that we want to push back on. Question: do you feel that the appellant had have you seen reassessing an amended T2 after the 1 year and 90 days has passed? So if CRA issues a reassessment, if you've amended a T2 and CRA has issued a new notice of assessment or a reassessment, that is going to trigger the year and 90 days to start counting. And when that year and 90 days is over, no, it's very like there's very little you can do. T1 adjustments, if something's been if there's been a notice of assessment, a T1 or T2 adjustment to amend it is something that CRA may consider. As sooner as if CRA has audited tax year, a T2, and then issued a reassessment, then you definitely cannot challenge that reassessment with a T1 or a T2, either within the year and 90 days or afterwards. So I have had accountants say to me, oh, well, sure, I missed the year and 90 days, but I'm just going to file a T1 or T2 adjustment. If there's been a reassessment, CRA will not allow a T1 or T2 adjustment to overturn a notice of reassessment. CRA won't even look at it. This is another tough one. This was almost going to be one of my surprises. Are court costs and legal fees recoverable for a winning taxpayer? So this is another kind of downer surprise. If you win a tax dispute, you can get costs back, but they are at a fixed amount and they are so low relative to the amount of work that it actually takes to win a tax dispute that the amount is relatively minuscule. It's almost symbolic instead of actually anything close to properly reimbursing a taxpayer. So that's an extremely frustrating thing for taxpayers. You can have a taxpayer who's entirely right and go all the way through the tax court process and recover very little of their costs. And if CRA then decides to settle, at the last minute, you're probably going to you can try and recover costs, but it's going to be even less. So it is that's maybe one of the most frustrating things for taxpayers is if you get caught in one of these things, whether there was something that was slightly the client's fault that triggered it, or there was nothing that the client did wrong at all. Unfortunately, the taxpayer has to bear the burden of fighting that, paying their accountant, paying their tax litigator to fight that out, and those amounts are not recoverable. So I know that's frustrating, and it's disappointing for all of us. One thing I would say though is anything you're paying, anything a client is paying as far as legal fees for a tax dispute is at least deductible. So it is deductible to the person who pays it. So that's a very, very, very small consolation. This will be my last one. The respondent typically pleads the total income assumption in. Okay. I think we are getting close here. Okay, I will do one more. Okay, somebody asked, do you take clients in other provinces. Yes, we can take clients in other provinces, and now our work, we're finding more and more that we're getting work from Toronto, work from Vancouver, because we're dealing with federal legislation. We can take clients from other provinces. Not that's different, I think, for different types of law, but when it comes to CRA tax disputes, we can and we do. So that brings us to 2:30. Thanks so much for being here. I've really enjoyed sharing this information with you. I hope you find it valuable, and I look forward to reading your survey results. Thank you so much.